Okay, 1 minute before time. So good afternoon, good morning, or good evening for those who are joining us from different time zones. It's a great pleasure to moderate the session of the WTO Public Forum about plurilaterals and WTO reform. My name is Alexandre Parola. I'm the permanent representative of Brazil to the WTO in Geneva. It is becoming commonplace to claim that the WTO is failing to deliver negotiated outcomes, that its negotiating function has been paralyzed, that it's failing to keep pace with the demands of the 21st century. There is, of course, an element of truth in all this. Right now, we're in a situation in which, if a group of WTO members wish to negotiate among themselves new rules or commitments and wanted to bring this outcome into the WTO framework, they might be prevented from doing so by the opposition of one or few members. This could happen even if the interests of those few members were not affected at all by the results of negotiations, even if they were affected positively by the results of the negotiations. This rigidity has paralyzed the negotiating function of the WTO in a manner that was probably neither foreseen nor intended by the drafters of the Marrakesh Agreement in the Uruguay round. It is absolutely essential to revive the WTO's negotiating function. In my view, if it proves difficult or impossible to get the agreement of all 164 WTO members for new rules or commitments, this should not prevent those that are willing to move ahead from doing so and doing it within the WTO. Plurilaterals could be the path to the much needed revival of WTO's negotiating function. Plurilateral and multilateral formats complement and reinforce each other. So this panel may seek to explore whether, and if so, how, a renewed approach to plurilateral agreements could be a part of the WTO reform. To address this and other questions, we have with us today three distinguished panelists. They are Dr. Gabriel Marceau, Senior Counselor in the WTO Legal Affairs Division and a professor at the University of Geneva. Dr. Vera Torstensen, minha antiga amiga, a professor at the School of Economics of Fundação Getúlio Vargas in Brazil, where she holds the WTO chair. And also an old friend, Professor Luizio Lima Campos, distinguished trade policy analyst and scholar in residence at the American University. But before giving the floor to the panelists, allow me to ask my colleague, Ambassador João Aguiar Machado, permanent representative of the European Union to the WTO, to also deliver some initial remarks. Please, Ambassador, the floor is yours.
Thank you, Alexander, and it's a great pleasure to be in this panel discussing a very topical and very important question regarding the future of the WTO. The European Union's reform agenda includes making it easier to negotiate new agreements that respond to important trade issues of today. And our approach implies that we allow those WTO members who want to move forward and address new topics that they should be able to do so and not be prevented by members that do not want to progress into these areas. However, any such agreement should have a number of features, as I will come at later. They need to be open and allow countries who want to join to be able to participate and to be part of the final agreement. There has been much discussion recently about plurilaterals and the WTO, that plurilateral agreements would damage the WTO. I think it's important that we look a bit back and see in the evolution of the WTO how it has been. Indeed, plurilateral agreements have been a feature and I would say even a driving force during the time of the GATT. in developing many of the rules and disciplines that were later incorporated into the WTO through the negotiations of the Uruguay round. If you look back, most of the first rules that were developed in the Tokyo round, in the so-called codes, be it anti-dumping, on subsidies, on government procurement, these were all plurilaterals in a sort. It only involves certain members, and it was the only way to develop a number of rulemaking that was necessary, felt necessary at the time, and later they were incorporated into the architecture of the WTO. So plurilateralism is not something new, and it's not something that is necessarily anathema to the WTO. Indeed, they have been a driving force in the past. Secondly, it's clear that the WTO negotiating arm, the negotiations in the WTO, have been unable for many years to deliver on results that involve topical issues and issues that our societies are interested. And in order for WTO to become relevant and remain relevant and credible, we cannot avoid addressing these matters in the trading system, even if not all members are prepared to move at the same time. We need to have space that allows those members willing to move to be able to do so. Therefore, for us, for the European Union, it is vitally vital that for the WTO credibility and relevance, that we maintain the option of developing rules that respond to the issues that our societies are interested today and to the realities of the 21st century. Indeed, the rule book that we are operating today is a rule book that was developed last century and do not reflect any longer the realities of economies in the 21st century. And indeed, what we see today is that you have already a very large number of members that are participating in plurilaterals under the form of the joint statement initiatives on services domestic regulation, on e-commerce, or in investment facilitation. And also contrary to the normal theory, in these joint statement initiatives, participate, it's not only the rich developed countries, you have a lot of developing countries who are interested and are participating actively in these plurilaterals called joint statement initiatives. And indeed for MC12, we are going to have a first joint statement initiative that will be concluded on services domestic regulation. And I think that will be a good signal that while the multilateral function of the WTO negotiating function has been unable, and even today we are facing tremendous difficulties if we look at the fisheries subsidies negotiations, which is the only multilateral negotiation going on, the plurilaterals under the joint statement initiatives are going to deliver results already at MC12 in the form of conclusion of the negotiations in services domestic regulation. So in our view, if we don't allow for that space, for that flexibility in the WTO architecture to allow members wishing to progress to do so, the only alternative and the reality of things will lead that the rules will be developed anyway, but they will be developed outside of the WTO. And I think that will lead even to more fragmentation. Our preference is that these rules are developed in the WTO, leaving the possibility for later on for more members to join and to be incorporated in the WTO architecture. However, the European Union takes the view that in addressing and in negotiating plurilaterals, this should not be regarded or designed as to be initiatives only for a close group of friends or a close group of countries that have a certain level of development. This needs to be open to whoever wants to participate. They need to be inclusive. and they should leave the chance for developing countries that want to join and sign these agreements to be able to do so. And those that decide not to join at a certain moment, we should leave the open the possibility for them to join later on. So in a short term, in a short word, this should be open and inclusive plurilateral negotiations. And there are various ways, and this has been the discussion that we have had in the General Council in the last months. There are various ways to incorporate plurilaterals into the WTO architecture, first through Article 9 of the WTO agreement, but it requires consensus in order to be included in Annex 4. But if you move to services, there is flexibility that is provided in the GATS agreement in terms of members being able to inscribe additional commitments in their schedules. And again, I think it's an important point because there has been much discussion here in Geneva that negotiating plurilaterals will be against the grain of the multilateral trading system. I beg to disagree. If you look at the services agreement, the GATS agreement, it's written clearly in the GATS agreement that future negotiations should be developed through bilateral, plurilateral, and multilateral negotiations. It's clearly written in the GATS agreement that a plurilateral negotiation is a viable option. So as part of the future work and as the decisions that are going to be made at MC12, the European Union is very much looking forward that we take a decision that we start exploring with interested members how we can make the negotiating function of the WTO more efficient, allowing for plurilateral approaches in the WTO, and also a discussion of how best to incorporate these agreements later into the WTO architecture. So, Alexander, that's what I wanted to say as a starting remarks. I would leave just a question also for the panelists that I think it's important. I referred already that there are at least right now 3 joint statement initiatives on domestic regulation in services, e-commerce, and investment facilitation, which are in fact plurilaterals. And I would be very interested to hear the views of the panelists on whether do you think that we need more to anchor these initiatives into the WTO architecture. Thank you.
Thank you very much, João, for your introductory remarks and for the additional question that you put to our panelists. I have the pleasure now to give the floor to our first panelist, Dr. Gabrielle Marceau, for her presentation. Please, Gabrielle, go ahead. You have 10 minutes.
Thank you, Ambassador Parola. Just a small correction. I'm not in legal affairs division anymore. I'm in research. So it gives me a bit more space for today's presentation, which I do in my academic capacity. And I would start in saying that I will focus on GSI and plurilaterals, but the specific of GSI, which to me are evidence that the WTO is in the process of being reformed, because to me, GSI are a reflection of a new form of multilateralism that I would qualify as non-static, but rather evolutionary. And I'll start with a few principles that you all know as ambassadors. First, WTO members have a fundamental right to initiate negotiations. Contrary to the GATT, the WTO is a permanent forum of negotiations under Article 3.2 of the WTO agreement, and there's no legal requirement for a decision of all members. In addition, states have the obligation under due diligence principle to protect their people and their economy, and thus to discuss and collaborate with other governments to improve regulatory networks covered by subject matter of the GSI inter alia. So there has to be a place where to put this. And I will argue that GSI text concluded by a subgroup can be today part of the WTO, implemented and continue to develop in terms of membership and even content, and eventually maybe more formally integrated, but they are already possibilities. Another fundamental principle is, I would argue, that there are no rules of procedure or voting rules that can nullify the fundamental right of states to regulate. And I would even add sometimes the fundamental obligations in area like e-commerce and cybersecurity. My view, states have the obligation to regulate, and if it affects trade, they must go ahead. Another important principle is that in international law, the Vienna Convention, Article 41, is categorical. Members, or rather states, have the right to modify multilateral treaties between a subgroup, but there are conditions. One condition is that it's not prohibited, which is not in the WTO, and that the rights of others are not affected, the other signatories, and it doesn't basically, it's not incompatible with the fundamental principle of the treaty. All these conditions are respected in the WTO because, in my view, no fundamental rules of the WTO would be violated, including MFN, because even if, and I'm thinking of the e-commerce, all benefits are not automatically given to all, I think all benefits resulting from the GSI would be offered to all those who comply with the GSI conditions. So the ambassador from Europe has already listed the different ways where governments can introduce a new sort of agreements. The regional trade agreement exists, government procurement, but regional trade agreements, you need some substantial cover. Government procurement, you need consensus, waiver consensus, etc. There is another way, and it's been talked already on two webinars today, to add, modify rights and obligation can be done through introducing new provisions in member schedules. And this is possible because in GATT and still WTO, there are two main types of rules in the system. You have those written texts in the covered agreement that are generally the same for all members, and you have the schedules that each member has. Initially, the schedules were limited to tariff, but throughout 70 years of trade, schedules expanded to cover government procurement, subsidies, services, etc. The jurisprudence is clear that schedules are considered treaty texts, the old appellate body said, and should be interpreted and applied as treaty texts. They're not supposed to clash with the main provisions, but they're essentially equal. And I believe that if you add the GSI text to existing schedule or even new schedule, which I will suggest for e-commerce, it's possible to do what others have said. So it's been said already, the ITA, financial service note, the telecom reference paper, and I add the Geneva Banana Agreement, which I worked on to assist Lamy at the time, which was put in the EU schedule and signed by some 30 countries. And it did not deal only with the dispute, it dealt with EU enlargement, with the waivers, with 28 process, etc. And this was considered to be a valid way to bind the EU. Bind the EU not only in terms of market access, but also with some conditions. And this is not new. In 48, when the old Article 2 of the GATT on tariff was adopted, it does say governments will respect the tariff commitment in the schedule, subject to terms, conditions, and qualifications. So already in terms of principle, it was considered that governments can add terms, conditions, and qualifications, which I believe the GSI is of that nature. I'm not saying GSI should be scheduled in Article 2 tariff. I'm talking about the constitutional possibilities. Now, which schedule? That's an interesting issue. Some are obvious, domestic regulations, or even investment facilitation. Hamid wrote an excellent paper a few days ago explaining how to integrate that in additional commitments of the GATT. There are GSI where it's more complex, e-commerce that touches GATT, GATS, and TRIPS. In my view, a new e-commerce schedule should be put in place by GSI members, and it would be a horizontal. This has been done, for instance, by some members who developed a new part to their schedule to register export restrictions. There are head notes that exist, etc. There's a problem some people raise about certification, the risk that those who change their schedule would be opposed by outsiders. I would simply say that certification is essentially procedural and, in my view, could not nullify the negotiated provisions in the schedule. In my opinion, the GSI members, if they incorporate the schedule in their schedule, the GSI text, in fact, are expressing a commitment to regulate the concerned matter in a transparent manner for all members. And as I also said a bit earlier, I believe that the benefits of the GSI are the result almost exclusively of the operation and respect of the conditions of the GSI. So those who are not in the GSI are not losing any benefit. They may not have access to the benefits caused resulting from the GSI, but they will be invited to join in and respect this, the condition, if they respect the condition of GSI. So GSI are also essentially non-static, I mentioned, because the membership can grow in them. And if you put them in schedule, they can be modified, improved, and eventually introduced elsewhere, possibly in the annexes. I believe that states have the right to implement unilaterally their own determined sort of regulations and market access rules in their own schedule. And if this is done voluntarily by several countries, that is by 100 or more, depending on the GSI, it will help stabilize the GSI. And importantly, it will start developing what we call state practice, which is again very important because it gives legitimacy and it would somehow improve the institutionalization of GSI. Think of the enabling clause that was adopted after the Tokyo round had been sent to capitals for being ratified. Here in Geneva, governments adopted a right to violate MFN and privilege developing country. This is clearly inconsistent with the rules, but it was practiced and recognized for some 25 years before it was codified. My time is over. I just want to add one point, that it's possible for members to adopt the GSI that would continue to evolve. Just think of what WTO members did with the rules of conduct, the rules of ethics in '95, when there were still tensions about textile dispute, governments could not agree. The appellate body adopted the rules of conduct as they stood at the time incomplete, and just committed to re-adopt them when they would be complete. Governments have the capacity and should exercise this sort of possibility of adapting to the needs in order to respect their fundamental right mentioned by the Vienna Convention to continue to push forward their regulatory powers. And I say thank you to all, and just remind you that it's not the only area where subgroup have adopted norms that affect the others. I'm thinking of mutual recognition, equivalence regimes, international standards. All these things are done by subgroup, but the entire membership sort of recognize it. So I believe it can be done today, but of course it's only one of the way. And as the EU ambassador mentioned, it could be made more clear. I believe it's possible. And I thank the three conveners of all those different GSI for all their work. And I thank the ambassador of Brazil and EU for inviting me. Thank you.
Thank you very much, Gabrielle. Now it's my pleasure to ask our next panelist, Dr. Vera Torstensen, to make her presentation. Vera, the floor is yours. You have 10 minutes.
Thank you very much, Ambassador. It's a pleasure to see Ambassador João Manuel also here. João, please. After listening to Gabrielle, and I fully agree with her, it's amazing how many ways we have to go ahead with this issue. And my problem here, my question here is why things are not moving. So in preparing to this panel, I tried to understand the position of the opponents, let me call them opponents. And what they are saying is, well, they are afraid in the sense that these agreements, plurilaterals can be used to push these agreements on them in the future, as happens with the old plurilaterals one. And then I went to, and they need policy space, and I tried to understand what's going on behind as an academic, right? And then I started studying the agreements that India and South Africa and all the countries in Africa, what kind of agreements they are doing. And so I discovered the funny thing that, remember in 95, we are living the glorious days when the WTO is the center of gravity of all the economic world. And then there is a marvelous book from Professor Bhagwati saying, look, take care, you multilateral persons, that preferential arrangements at that time, regional arrangements, you'll be spreading the spaghetti bowl and so on. And then we move to 2020, and what we have a completely paralyzed WTO, and we have a multitude of preferential arrangements. 350, something like this. And now in my double chair here in Brazil, I study the basic of WTO, but I teach also the agreements, what we call the last generation agreements. And so I'm teaching WTO rules by the agreements of the European Union, the agreements of the United States, because they have different kind of models. And this is the consequence of paralyzing WTO and not allowing plurilaterals. That is, countries are moving, and I'm trying to discover if in their preferential arrangement, these reluctant countries, what they are doing. So what we have here, and quite interested in the scenario, is that you have the deep agreements of the European Union and even the United States, TPP and all this, but you have a new animal in the field, that is RCEP. And RCEP for me is more or less what kind of another plate in the balance. That is a quite shallow agreement in the sense that is only tariff and only rules of origin. It's amazing what they are doing with rules of origin. And I'm trying to see how all this is going to the shallow agreements and deep agreements, how this is going to what will be the effect on WTO. So, and we are studying here in the WTO chair also the impacts of the countries like Brazil, India, and South Africa not having deep agreements. Because if you go to the modeling exercise, you cannot put, very limited agreements as a full agreement. So, and the impacts are already clear. The numbers of the impact of Brazil not having preferential agreements, India and South Africa is amazing, not only in GDP, but also on the flows of commerce. So not impeding the movement ahead of WTO. And not having more deep agreements, the effect on us will be quite significant, the ones that are not in the group. Now to the plurilaterals. I fully agree. I'm reading a lot of material and I'm completely lost in the forest of the lawyers. Because it's amazing the quantity of arguments against and in favor of of the plurilaterals. And my point is just, and I will finish with this, in these impacts, in this moment, can we try to go ahead with, instead of hard law, with something less than hard law? Gabriela already listened to me talking about guidelines, and she helped me a lot in rules of origin. When the agreement was impossible, Gabriela suggests, let's try guidelines. Why is this so important? Because it's not hard law, it is soft law. You can do it, you can negotiate it, nobody's against it in the WTO. I think that Gabriela gave the reasons already. So I think there is a kind of, in the arguments against plurilaterals, I read a lot of things, the fear of doing something that we do not know. And so why not to test? And why guidelines is so important for me? Because we establish a level where the agreements, the new preferential are going to play, even for the opponents. Even the opponents, we're going to see that we are having a guidelines on this issue. And then the countries can choose the European model of all the digital and investment facilitation and so on. Environment, look, we need a plurilateral environment also. And then either the United States or the European Union. And for digital, why not see something based on what China wants to? So guidelines to help the other, how many countries out of these models to play to see what's going on. My fear is that without plurilaterals, without negotiations, the multiplication of the deepening of their preferential arrangements, the model of the European Union that I follow with care, the model of the United States. Let's see what's going to happen. Can you imagine what will be the reaction of the US after China wanting to participate in CPTPP? So, and we are doing this kind of model. Let's put the United States again in TPP. Let's and see the rules behind the TPP. So this word is quite challenging and quite difficult for me to see. So again, let's try to see if a guideline solution instead of hard law, a soft law, to put more power, to give more power to the Secretariat. I hate the member-driven principle. That is, look at what the whole of Secretariat. And these 4 guidelines, Secretariat is really important because they are going to show who is following the guidelines or not. So this is my proposal is, I still think that WTO is really a prisoner of the law, of the lawyer specialist, in the sense, please, we need more power to the negotiators. I think that negotiators are afraid. Come on, there's no more WTO dispute settlement. Let's see if the negotiators now can move ahead a little bit and push a little bit on lawyers. Because after reading so many articles, it's amazing and it's nice to see Gabriel say things so clearly. I think that lawyers are too much in power now, and I think that negotiators must be in the right place. Thank you very much, Ambassador.
Thank you very much, Vera. I have the pleasure now to invite our last panelist, Professor Aloysio Campos, to deliver his presentation. Aloysio, you have 10 minutes. Thank you.
Can you hear me well? I had some technical problems here, so let's see if we are able to get to the end here without any problems. First of all, thank you very much for inviting me. It's a pleasure and an honor to be with Ambassador Parola, Ambassador Aguiar, Machado, and Gabriel Masso, that I hasn't seen in some time. At least I'm seeing her virtually. And of course, my old friend Vera. There's some benefits of being the last one. I can focus on something that has not been covered yet. I'd like to thank Gabriel for covering all the possible ways of doing it through the legal side of things, and to Vera for looking outside the box and presenting some other alternatives. I'm going to be more materialistic and more focused on what I call the toolbox. I think that we have two types of plurilaterals. We have the open type, or MFN type, if you like to call it that way, which are the ones where rights are going only to, rights are for everyone, every member, while obligations only to the subscribers. While the exclusive or non-MFN agreements, like the GPA, they only revert rights and obligations to the subscribers. So these are the two basic types out there, and I think that if we're going to look into plurilateral as a way to go forward, we need to have a complete toolbox and be able to do both. And we do have some mechanisms by which we could do that. The open type doesn't present much of a problem. We have an excellent example in the ITA, in the technology agreement, where today you have pretty much 97% of the trade under this agreement covered. It was an open agreement, but it took about 20 years to get from the original 20 plus subscribers to today's about 80 plus subscribers. So it's a longer period in order to get a complete coverage of this agreement. Now, if we look at the exclusive agreements or the non-MFN agreements, I would like to use the GPA as an example, because it's one that if we test, if the GPA was being negotiated today, it would never make it to Annex 4 under present rules and regulations. And the reason is that you have in Article 9.3, for example, a voting procedure for an MFN waiver. And this is something that could be pursued if a closed agreement, a non-MFN agreement was being proposed by a group of countries. However, if we go through the voting procedure, which is 3/4 votes would give you that waiver, but there's some requirements. You need to show exceptional circumstances. The waiver must be temporary, and it will be subject to a yearly review by the ministerial. So this is sort of already a very burdensome way of getting it. But let's say you're successful, and what's the next step? Will be, of course, to put it in Annex 4, but then Article 10.9 would require consensus for that. Then why having a voting procedure when you have a requirement for a consensus to include it in Annex 4? It doesn't make much sense to me. And it's probably a place where we can look and search for, or my suggestion would be to make it more flexible, or maybe carve out a separate procedure for plurilaterals instead of putting everything in the same basket. Now, I agree that changing the rules instead of schedules is more difficult. It would require more negotiations, of course, but I think it's, the way I see it, it will be a challenge for the negotiators to pursue, because unless we can resolve this, I find it very difficult to be able to legally, under the regulations, include the plurilateral in Annex 4. All this based in the idea that it's better to have these agreements, plurilateral agreements, under the WTO rather than outside. Because today the incentive is to have this kind of plurilaterals outside the WTO. And even though we can say that substantial coverage of substantial agreements for a substantial coverage of trade in order to have a free trade agreement is something that would be required. There are ways to go around that. We know, countries can get together and say that this is phase one of a broader agreement and go ahead and do it. So we would like to avoid that. We would like to have the WTO having monitoring this kinds of agreements and have these agreements under WTO rules, even though we don't have a dispute settlement in force, which could make any violations enforceable. I would say that this would be a more effective way of covering these agreements. So I'll stop here and be open for any questions. Thank you, Ambassador.
Very much, Aloysio. I think we have had some very interesting ideas raised and debated here. Let me see if we have questions coming from the audience. We have one very interesting question here, and I'll read it. Could WTO members perhaps also start to include climate change concerns in their schedules, given that they probably have an obligation to regulate climate change domestically? The question was specifically posed to Gabrielle.
Thank you, Ambassador. So in my view, yes, climate change could become a condition put in the schedule. The problem is if you did not put such condition in your schedule, so there are all sorry. So my answer is yes, governments have the right to put conditions such as climate change or whatever in their schedule. It's mentioned in Article 2, but you have the same principle in GATS, but it has to be negotiated or rather put in the schedule for transparency. Problems occurs if it's raised afterwards, after the schedule, but in my view, no hesitation. And if you allow me, Ambassador, one point that I would like to add is that, whether it's soft law, hard law, the solution of schedule that is far from perfect, it's not the royal route, but it's a route. And it is, as the title of your panel, a sort of temporary, adequate, appropriate solution that will, as I mentioned, stabilize the situation that could be improved. And to me, GSI are really part of the WTO framework. When the other speakers say there's a risk that it goes outside, maybe, but meetings take place here. And it's amazing. If you go to, I only follow the e-commerce negotiation, if you attend the meetings, it reminds me the energy that was in the air when the WTO started and I was a young lawyer and I arrived, selection of the appellate body and all that. Then for years it was calm. If you attend GSI meetings, governments are really negotiating. It is real multilateralism. It's a new form because it's not everyone. And you see concessions, you see texts. The conveners are doing an amazing work. This is real stuff. And the procedure cannot kill the substance. It's important to maintain the deliberative function of the WTO, and the governments and the ambassadors should not sort of hide behind procedure. On the contrary, they should elevate the substance of what GSI is all about, if you allow me, because it's the public forum.
So very much. I think we have had a very good debate, and I want to thank all those in the audience who have participated following us today. Now it's time to conclude, and I will ask Ambassador Machado if he could give us some final thoughts before we close the session.
Thank you very much, Alexander, and the panelists. I think it has been an extremely interesting exchange with a lot of food for thought and ideas that I think we will be exploring. I think it's a very topical issue that will remain with us for many years to come, and it's an important one if you want, as I said initially, the WTO remains credible and relevant to address the issues that we have today. I just want to conclude to put 2 points. I mean, if you draw, and I hesitate always to do that, a parallelism with the process of the construction of the European Union. Initially, we were 6 countries, very much monolithic. All of them shared more or less the same perspective. Later on, we grew, we are 27. And we saw that unless you had or let the possibility to develop with a variable geometry, we would not arrive anywhere. And I think the same we are experiencing here, and again, with the differences that are important, but I think many are similarities with 164, with a variety of levels of development and the types of economic systems, unless you left the space for those that are willing to advance without closing the door to the others, but leave the possibility those who want, the system will asphyxiate, and it will be the end of the system, and people will look elsewhere. So I think there are important lessons to be drawn, and I think that we need to devise ways that this not become only an exercise for an exclusive group of members. And it's not, because if you look at the GSIs of today, you have a variety of members, developing countries, least developed, that are participating and are interested. So I think there is a possibility, and we need to move beyond this dichotomy that it's against the WTO, it's not foreseen, this will be the end of the system. No, if we don't create that space, then the system will end. That's our firm conviction. Thank you very much again to all panelists and to yourself, Alexander.
Thank you very much again, and thanks yet again for each of the panelists. Let me draw on something that you said, João. When we discussed this matter, colleagues here in Geneva, it's very easy to get the impression that the move to revitalize plurilaterals would spell doom, the end of the world of the multilateral trading system. I couldn't disagree more. And they say, oh, the system will be fragmented. The world is already fragmented. So the choice is between fragmentation and paralysis. Paralysis leading to irrelevance. We need to be very, very clear about this. And let me mention something that Vera said about the lawyers. And I'm not a lawyer myself, but in defense of lawyers, this is not a problem that is being created by lawyers. This is a problem that has been created by those who are very strong defenders of the status quo and understand fully well that plurilaterals will revitalize that and will allow us to move ahead. If you do not want to be ruled by norms, that's the good way to go. Say, no, it's impossible, you cannot do that. Let me finish with a just very etymological note. The prefix pluri and the prefix multi, they mean essentially the same thing. Let's imagine that we have e-commerce, for instance. Let's imagine that it has 163 members. Is it multilateral or plurilateral? Well, let's ask a linguist and a grammarian to decide about that. Let's leave the lawyers in peace for a while, and let's ask for a grammarian to help us with this. And another lesson that we have learned today, and I really benefited from this debate, is a very clear message that is not about whether this is going to happen. It's about where this is going to happen. The world and the world economy is not going to wait for the WTO to solve its own problems. Plurilaterals will happen. So the question I had before our eyes now is, are we able to integrate this within the framework of the WTO or not? And depending on how we answer this question, and depending on the answer given to this question, it is the future of the WTO, its relevance that will be at stake. But once again, thank you very much. I hugely benefited from the collective wisdom of this panel. So thank you very much again.
Thank you.
Thank you.
Bye to all.
Thank you, Ambassador.